For several decades, we were instances of governors sitting on bills and not giving their assent. Normally, these are governors aligned with the ruling party of the centre, and the bills that are held up almost invariably belong to opposition ruled state. The governor of Tamil Nadu, R. had been sitting on 10 bills passed by the Tamil Nadu Assembly between 2020 and 2023. So earlier this year, M.K. Stalin, the Chief Minister of Tamil Nadu, took the matter to the Supreme Court. On April 8, 2025, a two-judge bench of the Supreme Court declared the bills as passed and ruled that in general, governors had to act on bills passed by legislatures within 3 months or they would be deemed assent by the governor. Now, aggrieved by this decision, on May 13, 2025, the President, that's actually the central government, asked the Supreme Court for an advisory opinion under Article 143 of the Constitution. The question: could the courts lay down a time limit by which the governor and the president are obliged to act on bills passed by the legislatures? On November 20, 2025, or about a month ago, a 5-bench judge of the Supreme Court, in a unanimous opinion, held that the Supreme Court cannot impose timelines on governors to clear bills. Surprisingly, this opinion is unsigned. Most decisions of the Supreme Court are signed by at least one of the justices on the bench. The good news: this is an advisory opinion, so it is not binding on any court in the land. The bad news: in my view, it is a flawed opinion. I do not wish to read the 111-page judgment from the Bureau. So let me quote a couple of paragraphs from the summary on page 108, 165.1. The governor has 3 constitutional options before him under Article 200, namely to assent, to reserve the bill for consideration of the President, or withhold assent and return the bill to the Assembly with comments. Fine. But what about the time taken by the governor? The main question at hand. There, the summary of the judgment goes on to say, now this paragraph 165.3. However, in glaring circumstances of inaction that is prolonged, unexplained, and indefinite, the court can issue a limited mandamus for the governor to discharge his functions under Article 200 within a reasonable time period without making any observations on the merits of the exercise of his discretion. Excuse me, your lordships. What are you saying? Is that the governor cannot sit indefinitely on a bill, right? Which is exactly what the two-judge bench also said. But we thought you were going to, how shall I put it, define your judgment in terms of what you mean by glaring circumstance of inaction that is prolonged, unexplained, and indefinite. And then you were going to specify, quote, a reasonable time period, unquote. But 165.3 leaves us exactly where we were. The advisory speaks of prolonged, this word prolonged. For instance, as per the Times of India, there is a bill from West Bengal pending for 9 years. Is that prolonged enough? Or is Mr. Ravi's 2 to 5 years sit on the bill the norm? Frankly, the advisory opinion, in my opinion, is as clear as mud. I think a lot of this confusion could have been avoided if the judges had sought in these uncharted waters the views of the framers of our Constitution, just the way the US Supreme Court often relies on the Federalist Papers to derive the intent behind the Constitution. The issue of the role of governors, the kind of persons who should occupy the office, whether they should be elected or nominated, and their emoluments was all discussed in great depth and at great length by members of the Constituent Assembly. On which day? On May 31, 1949. Unfortunately, their consensus on what the governor can and cannot do has been totally ignored in the Supreme Court advisory opinion. For those who are interested, please go to Constituent Assembly Debates, Proceedings, Volume 8, and get all the gory details. Now, let me quote from the chairman of the drafting committee, Dr. B.R. Ambedkar. Dr. Ambedkar, on 31st May 1949, and the direct quote from Dr. Ambedkar, said, "The drafting committee felt, as everybody in this house knows, that the governor is not to have any kind of functions. To use a familiar phraseology, open quotation marks, no functions which he is required to discharge either in his discretion or in his individual judgment, close quotation marks." Dr. Ambedkar then went on to say, according to the principles of the new constitution, he is required to follow the advice of his ministry in all matters. Let me repeat, in all matters. Dr. Ambedkar also summed up his views on why the governor should be nominated rather than elected, and his position in the constitutional scheme of things. Again, a direct quote. Having regard to this fact, it was felt whether it was desirable to impose upon the electorate the obligation to enter upon an electoral process which would cost a lot of time, a lot of trouble, and I say a lot of money as well. It was felt nobody, knowing full well what the powers he is likely to have under the Constitution, would come forth to contest an election. We felt that the power of the governor was so limited, so nominal, his position so ornamental, that probably would come forward to stand for election. That was the reason why the drafting committee thought another alternative might be suggested. By the other alternative, Dr. Ambedkar meant nomination for the post of governor, a practice that we have followed since the Constitution came into force. In this Supreme Court advisory opinion, however, the governor, whose role, according to Dr. Ambedkar, was ornamental, has been elevated to Olympian heights. I'm sure the King of England would envy the powers of our governors. In parliamentary democracy of the Westminster model, with a written constitution as we have, it would be extremely iniquitous and an affront to democratic principles to allow an unelected governor to impose his views on an elected legislature, except if the bill is believed to be unconstitutional and needs to be referred to the Judicial. That is an exception. Let this advisory opinion stay as it is, advisory, and let the Supreme Court or Parliament set out with total clarity the powers of an unelected and nominated governor. Let me end with an interesting quote in the Constituent Assembly Debate on Governors. The quote is from Biswanath Das. Under the 1935 Act, Indian provinces had prime ministers, and Biswanath Das had been the Prime Minister of Orissa. Here is his direct quote. Sri Biswanath Das, Orissa General. Sir, it has been stated that the governor has very little functions. If he has very little functions under the setup that we have laid down in the new constitution, then by heaven, the governor is getting a decent salary and is getting allowances. And if the functions prescribed for him are not very useful and necessary and not worth the money that we pay, I think it is time we give the go back to the governor. Perhaps Dr. Ambedkar should have listened to Vishwanath Das. Thank you.